One clause that can save or destroy your international business. Let me ask you something. If your biggest international deal collapses tomorrow, do you know exactly where the dispute will be resolved? Which country? Which law? Which procedure? And how enforceable the decision will be? Because if you don't define it, you don't control it. And if you don't control it, you will pay for it. Today I am going to show you the one clause that separates sophisticated international contracts from expensive legal disasters. In international trade, contracts don't fail because of price. They don't fail because of delivery terms. They fail because of poorly drafted dispute resolution clauses. I have seen multi-million-dollar transactions collapse simply because of the arbitration clause was copied from the internet. So today, I will give you a standard enforceable arbitration clause and explain why each part matters. Before we begin, if you are involved in cross-border trade, investments, or international contracts, subscribe to this channel because here we don't discuss theory, we discuss what protects your assets. Here is a professionally structured arbitration clause. Any dispute, controversy, or claim arising out of or relating to this contract, including its existence, validity, interpretation, performance, breach, or termination, shall be finally resolved by arbitration under the rules of an arbitration center. The seat of arbitration shall be a place, like a city or a country. The arbitration shall be conducted in English language. The tribunal shall consist of one or three arbitrators. The governing law of this contract shall be the law of a country. The award shall be final and binding upon the parties. Now let's break this down. Arising out of or relating to. This prevents jurisdictional loopholes. Seat of arbitration. This determines procedural law and court supervision. This is strategic, not symbolic. Governing law. Substantive law. Different from the seat. Never confuse the two. Final and binding. Critical for enforceability under the New York Convention. If this clause is drafted correctly, your arbitral award can be enforced in 186 countries. If drafted incorrectly, you may litigate for years. Let me be direct. An unclear clause can result in parallel proceedings, jurisdictional challenges, anti-suit injunctions, non-enforceable awards, which means lost time, capital frozen, reputation damaged, all because of 5 lines in a contract. Arbitration is not just a clause. It is a risk management mechanism. It is an asset protection strategy. It is a cross-border enforcement tool. If you trade internationally, your dispute resolution clause is not parallel. It is structural. If you want custom arbitration clauses, strategic contract review, international enforceability structuring, contact me directly. Details are in the description. And if this video clarified something important for you, like, share, and subscribe the channel. Because in international business, precision is not luxury, it is survival. Good luck.